Before we get started, we'd like to thank Nationwide for sponsoring this episode of Let's Get Surety. When you partner with Nationwide Surety, you know you're working with a strong and stable carrier that has a wealth of experience. Nationwide Surety Operations specializes in both commercial and contract surety bonds to support local, regional, national, and international customers with operations in the United States. For more information on Nationwide Surety Solutions, visit nationwide.com/surety. And now, on to our show.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks for joining us for this episode of Let's Get Surety. Today I have with me my co-host, NASBP CEO, Mark McCallum. Hey, Mark.
Hey, Kat. Glad to be back.
It's always good to have you on with me. And today we're going to be talking about the alternative dispute resolution, or ADR. So to do that, I don't think we could have a better guest than Bill Ernstrom of Ernstrom ADR. Hey,
Hi,
Bill.
Kat. Thank you for asking me to join.
Well, thanks for being a repeat podcast guest with us, Bill. It's great to have you on again.
NASBP is one of my favorites, as well as your executive director. So anytime.
You're in select company being a repeat podcast, so you're in good company.
I appreciate that.
So, Bill, before we just dive into talking about alternative dispute resolution, would you be able to just tell us a little bit more about your background and tell us about Ernstrom ADR?
Sure. I'm a recovering construction lawyer. That's where I start. For the last 15 years plus, I've been a senior executive in two national contracting firms, one in St. Louis, Alparisi Construction, and one in Chicago, the Walsh Group. Before that, I was in private practice, first with a big firm in Rochester, New York, and then I started my own firm there after being with that firm for a number of years. And our firm there focused solely on construction and surety issues. So I'm a recovering lawyer, and now, at the end of last year, I retired from Walsh and started Ernstrom ADR, which is a facility to help resolve disputes without the necessity of going to court, but also offering expert witness testimony as needed. So helping the parties get to resolution is the secret, and that's what I try to do.
So fisticuffs is not a good thing for a challenging industry like construction. Are there better ways here, Bill?
Yeah, there surprisingly are. I could show you my whip that I could use on occasion as well.
Those sound like painful processes. Maybe there's something that's more productive.
Yeah. Yes, there are. How do you want me to start going through that, or?
Sure. I mean, so when we hear the term alternative dispute resolution, those are three big words. What does that really mean? Are we talking about going the usual path of, we're in a dispute, we can't resolve it, let's go to court, or are we looking at other things?
Yes. It can be all of that. I mean, let's just start with the RTFC. Read the effing contract. What does your contract call for? And if it doesn't have alternative dispute resolution processes in it, you're already on a bad road. So it's something that you need to address early on in contract formation. So there are a number of. Go ahead, Mark. Do you want to jump in?
Well, I was just going to say, I'm getting the impression, Bill, that you don't think litigation is always the best path for a construction dispute. So you need a little forethought, right?
let me say it this way. I spent 16 weeks as a senior construction executive sitting in a courtroom in Los Angeles County with documents that would fill the NASBP offices floor to ceiling with a jury trial where 12 jurors, not one of them, I don't think, knew how to spell construction. So it was a, just a terrible experience.
I'm sure the judge was familiar with construction as well.
No, he was not at all.
He's like most other judges. They try to avoid that sort of stuff.
Well, we make light of it, but that is kind of more the usual situation than the unusual, that if you're going to litigation and you're going to have a trial, then that, a lot of things kind of go out of your hands, right? As a litigant, and then you're in front of people who don't know what you do.
Right. And then if you add to it the issue of construction has just in the U.S. has historically been a local industry with I know subcontractor A and I worked with subcontractor C and designer F. With the complexion of the industry and the complexity of the projects these days, it is the worst direction to go. And let me just add, from a construction company's point of view, it's not only bad in terms of all the money that you're spending on the lawyer and the expert witnesses and all of that, but it's the time that your senior project executives have got to sit in that room paying no attention to the current project that's going on, but trying to resuscitate a project where the bad things have already happened. I mean, it is a waste of time and effort to go down that path, in my opinion.
So maybe to explore it a little bit more, what does a litigation process do for business relationships? Are you going to preserve your relationship with the other party?
No. In fact, the situation that we had, it was a joint venture, without getting the name. It was a joint venture we were in with another national contractor against a national engineering firm, in fact, international engineering firm. And I doubt that either Walsh or our partner will ever do work with them again. And I don't think they want to do work with us again. So it all of a sudden reduces your opportunities to get different looks at the project that you want to build by not having the availability of, these companies to work with you or help you. So it's a bad thing all the way around.
And in such a relationship-driven space, that's got to be just horrible for business.
Yeah. It's terrible. It's terrible. And as I say, it just the feelings. I can tell you this for a fact on this last one in California. The feelings do not end when you walk out of the courthouse. They're still there, and they'll be there for a long time. A long time.
It's probably nice also to have that, drug out into the public view, right?
Oh, all of that. Yeah. So they're particularly when you have a big case like that, there are lots of people who are walking in the courthouse and, what's going on in here? And, come in and newspapers are in there and all that stuff.
Yeah.
So. Yeah. Privacy is thrown out the window.
Yeah.
So is there a better way? Is there a better path?
Yes. Yes, there is. And one of the things that I would, before going into the specifics, I would start with choosing your partners.
Okay.
That's a absolute key ingredient. Do you know them? Have you worked with them? Have you checked with your surety and bond and surety agent about what they can find out in the industry about them? If you're not doing that, you're really doing a disservice to your company in not having that sort of inquiry. So having said that, then there are a number of different levels. And, we like to talk about arbitration or mediation, but there's the alternative dispute resolution process is as broad and as flexible as you want to make it to be. You can do whatever you think makes the most sense. And that's what a number of the ADR people are doing. But let's just put that aside just for a second. So there's project team resolution, there's mediation, there's arbitration, and then obviously there's litigation. The project team resolution is what I was referencing earlier, but it's where there's a requirement in the contract that if there's a dispute, that it first goes to the executives on the project. If they can't resolve it, then it goes up the corporate chain, and so that at the end of that, the president or the CEO, chairman of the board of each of the companies are talking. And that's really what you're talking about, is talking, getting
right.
people to sit down, and more important than talking, listening to what's being said. So project team is I think a key ingredient to have in any balanced contract, and it's in all the consensus docs. It's not an unusual provision. And then mediation would be the next step, which again, you choose your mediator. This is non-binding. You choose your mediator and choose them well. There are lots and lots of people disguising themselves as mediators out there in the marketplace. So you need to do due diligence on them in terms of what experience do they have, who they mediated with before, can we talk to them, that sort of thing. Now, mediation is, as I said, is non-binding. So each side, the traditional way it's done is each side goes in and says, here's my view of the facts, there's their view of the facts, and the mediator then tries to convince you, that you're wrong, or at least raise some question marks in your mind as to how correct your position is, to try to bring people together. And there are some really, really talented mediators who have a way of, separating the herd, if you will, to get to the person that's creating the problem, and see what can be done there on a one-on-one. But the mediator can only make a recommendation. He can't bind you to any decision. So that's the most flexible next to the project. Most flexible is project resolution.
Bill,
arbitration then is the next.
Hey, Bill, before you get into arbitration,
yeah.
So tell me a little bit, in mediations, is that typically a fairly quick process? I mean, is that done in a matter of days as opposed to weeks, or, I know that when you were talking about the project team resolution, again, you're empowering the people who are most familiar with the project, right?
Right.
To at least to try to work it out. And if not, then you go to an outside party to facilitate. But how long is that? What is that process like?
Let's just go to the project team. There is no reason why the project can't keep on going while the project team is going to that. So in terms of having a restriction on project progression, there shouldn't be any in that setting.
Okay.
When you get to mediation, you're probably going to have some restriction on go forward basis, simply because you've got everybody that can make a decision usually in the mediation. Mm-hmm. So, and mediation again depends on the complexity of the project. We had one in Pennsylvania, building 584 bridges that the mediation took a long time to get there, but it got there. And so then the last step for litigation is arbitration. And you don't have to take these one after the other, but I would recommend that process be in the contract, so it gives you the option of doing that if it makes sense. Arbitration is the last step, which is binding. So if the arbitrator makes a decision, then your contract is probably going to say that that's a binding decision subject to confirmation by a state or federal court. So arbitration usually, depending on the size, 3 arbitrators. Again, selection is absolutely critical in that area, even more so probably than in mediation, because what they decide is going to be binding.
Do you see parties actually articulating how they're going to select the arbitrator ahead of time during the contract negotiation, or is that typically done after the fact? And can that in itself be a source of dispute?
Yes, and I would urge people to think about having a provision in the contract on that, whether it be using an arbitrator from thus and so, or actually picking an arbitrator. Subject that we had a problem with one arbitrator or one mediator where he just got sick. He was sick for a while, so that created a delay in the process. But that was pretty unusual. But arbitration, three people usually. It can be one person, it can be 3 people, but 1 or 3 is the more usual number. And they have it's more like a courtroom setting than the mediation. The mediator will take one side and kick the other side out for a minute and say, okay, here's all the problems I see with your side. And then he'll have the other side come in and kick that side out. He'll say the same thing. Here's what I see with problems with your side, but without telling either of the sides what he's saying to the other side. So it's trying to raise issues in the parties' minds about, well, maybe this isn't as good a claim as we think it is in the mediation setting. There's less opportunity to do that in the arbitration. Arbitration is just basically a mini trial with witnesses and testimony and perhaps stenographic notes and all that.
So is there some level of discovery in an arbitration? Like maybe not at the same level as litigation, but is that a component sometimes?
Sometimes it's RTFC. I mean, it depends on what the contract requires. Most arbitrations, the arbitrator will require some production of documents and a limited number of depositions. Again, if it's a big case. On a smaller case, let's say just give give the other side your list of documents and let's go.
So are these public processes or private?
Yes, that's a good question. No, these are all private. So the mediation and arbitration are private. So there's no outsiders involved in there unless there's an expert witness or something.
Right. So you get to keep that dispute kind of amongst the parties as opposed to out in the public domain.
And that's really, Mark, an important factor, because I think in terms of preservation of a relationship, either the mediation, less so arbitration, but arbitration more so than litigation, is the best way to try to preserve a relationship, rather than have witnesses be cross-examined in an open courtroom. That's no fun for anybody.
Right. So maybe you could touch on a little bit in terms of costs, what in generalities. So you have litigation, and then you have that kind of stepped process that you articulated, which I think now is in a lot of the standardized forms. There's some form of that. Obviously, if you can resolve your dispute early on, you're going to save costs. But just to give people an idea of, what it's like, mediation, arbitration, litigation?
Well, you've got in mediation arbitration, you've got a relatively high value dollar wise mediator or arbitrator or panel of arbitrators who are going to cost a lot, and depending on how long it goes, it's going to cost you a lot of money to have those people there. So it's the arbitration is the worst form, in my opinion, of the alternative dispute resolutions, because it has all the negatives of court in terms of how long you got to go through direct, cross, redirect, recross, but there's no judge there that's going to say, I'm going to rule on an evidentiary issue, because the arbitrator is not going to usually do that. So,
are those decisions, if you don't agree with them, easy to overturn?
I would say just the opposite, impossible.
Right.
Impossible to overturn. And if you're at that point, you really ought to be thinking about, how do we resolve this? How do we get people that were not involved in the project, that so don't have a cross to bear there to get in and resolve the things. It's I'll tell you, with the big projects today that are going on, arbitration is not one that I would choose as a dispute resolution process. It may work on the smaller projects. It does work on the smaller projects, but mediation and project level resolution are the best in terms of cost, both in terms of the actual physical cost and also the time impact on the project.
Well, it sounds like you're making the case for why people really need to think through how they're going to resolve disputes before they enter that contract, right?
Yeah.
Because depending on the complexity of the undertaking and the duration and all the rest, that they really need to be thinking through that.
And what's the nature of who you're contracting with?
Yeah.
You need to think about all those, and that's part of the RTFC principle before you sign the contract. The old I can't remember the fellow's name who wrote the book on the 7 habits of highly effective people. His mantra was begin with the end in mind, and that's what you need to do in terms of dispute resolution. Think about what the best way is to end this.
Well, I wonder if that maybe, I think that's great wisdom, but people don't like to think about the worst case scenarios. And maybe that's why they don't want to read that contract to begin with. And maybe that's why they need experienced advisors.
Yes.
So how do you pick somebody to help guide you in an ADR resolution process? What should parties be looking for?
What I always looked for is, who have you arbitrated for recently? Who have you mediated for? In terms of the lawyers, I wanted to talk to the company lawyers, and the bigger firms sometimes have get-togethers to talk about what their latest experience is with whomever, or you just pick up the phone and call somebody knowing that they just had Joe Smo as a mediator or arbitrator. So it's using your contacts, and that's again where an NASBP member or the surety was very helpful in terms of, okay, what's the skinny on Joe Schmo in terms of a mediator or arbitrator? I mean, that is very, very important. The preliminary evaluation of who's going to be one driving the boat is really, really important.
Well, that's an interesting point. So it sounds like the good ones may be booked up by the time you get into a dispute. So doesn't it pay to identify them early?
Yes.
And then maybe even name them?
Yes.
Yeah.
That would be the best thing. And we did that in a couple situations at Walsh where we named the mediator. In fact, said that if it goes to arbitration, you're stuck with us again. So, so it's you definitely should do that. That would be a smart thing to do.
That's great.
Awesome. Well, it's been great talking with you. What would your key takeaway be for anyone listening in today on ADRs?
What does the contract say?
That is, read the contract.
Read the contract. I mean, start with that. What does the contract say? I mean, if you think that it's a better contract because it doesn't have a dispute resolution clause in it, then
you're probably not right on that.
I've got a bridge to sell you in Brooklyn. I mean, it's got the dispute resolution process needs to be in the contract, and you the contractor need to understand what that means, and your NASBP member or your surety can certainly help you with that because they've been there, done that.
Right. Well, it sounds like you want to think this ahead of time before you sign that contract, because otherwise you don't want to be disputing your disputes process. So,
right.
Well, Bill, thanks again for all your insights.
Yeah.
We really appreciate spending some time with you today.
Anytime, my friend.
And Bill, if people want to get in touch with you or get more information on Ernstrom ADR, how can they contact you or get more information?
Sure. It's the same phone number that's been in probably people's contact list for 20 years. It's 585-737-2090. It's also on the web. It's ErnstromadR.com. So really difficult to address.
Well, thanks.
Give me a call directly on the Bill Ernstrom at gmail.com.
Awesome. Well, thanks so much, Bill.
Okay. Thank you.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.
Before we go, we just want to say thank you again to Nationwide for their generous support of this episode of Let's Get Surety. For more information on Nationwide Surety Solutions, visit nationwide.com/surety.